Hello friends, in the series on the income tax cases, today we will discuss a very important issue. The issue is that in what circumstances the Principal Commissioner of Income Tax can initiate the revision proceedings under section 263. First of all, the question arises that why there is section 263 on the statute. As all we know that only the assessee has the power to appeal against the order of the assessing officer. The revenue does not have the power to appeal against the order of the assessing officer. So section 263 is there if the department feels in the form of Principal Commissioner of Income Tax that the order passed by the assessing authority is erroneous and prejudicial to the revenue, then on the fulfillment of both the conditions, the Principal Commissioner of Income Tax can trigger section 263 revision. This issue has been taken up by the Jaipur ITAT A bench in the case of Sorab Sharma versus Principal Commissioner of Income Tax. In this case, it was discussed that according to explanation 2 to section 263, an order is erroneous when the order has been passed by the assessing officer without making inquiries and without doing verification. The second limb of explanation 2 to section 263 is that when the assessing officer allows some claim or relief without proper verification or inquiry, then also the order is erroneous. In the present case, the assessee has incurred some sales promotion expenses under two heads. During the assessment proceedings, the assessee was inquired 9 times about the sales promotion expenses, and the assessee has given all the possible details to the assessing authority, and the assessing authority has taken a very plausible view regarding the allowability of those expenses. But when the order was passed, the Principal Commissioner of Income Tax initiated proceedings under section 263 by saying that the inquiries has not been done, so the order is erroneous. The assessee went into the appeal into the tribunal against this section 263 revision order. It was the submission of the assessee that the revision cannot be initiated all the times on the plea that some more inquiry should have been done or there were short inquiries. It was the viewpoint of the assessee that at the time of the passing of the assessment order or at the time of the revision, if the sufficient material is on record that there is the allowability of the expenses of the assessee or the claim, then the revision should not be done. In other words, term record means whatever the record is available with the assessing officer or with the commissioner at the time of submissions of the assessee to the commissioner in response to the notice under section 263. When the tribunal heard this matter, the tribunal said that in the present case, the assessee was inquired in number of the times and the assessee has given all the possible details, and the assessing officer has taken a very plausible view regarding the allowability of the expenses. So for every short inquiry, the revision under section 263 cannot be done, or on the plea that more inquiry should have been done, the revision under section 263 cannot be taken. The tribunal said that Principal Commissioner of Income Tax should conduct inquiries to hold the order erroneous by simply making the allegation that the assessing officer has not done the inquiry. The revision should not be done. Friends, at the end, the tribunal deleted the revision which has been done by the Principal Commissioner of Income Tax on the point that the proper inquiry has been done and the Principal Commissioner of Income Tax has not been able to demonstrate that the inquiries have not been done by the assessing officer. Nowadays, we see that a number of the cases are coming for revision. So this case is very important to understand the explanation 2 to section 263, that what is inquiry, what is proper inquiry, what is short inquiry, and what more inquiry should be done by the assessing officer. At the end of this video, Once again, I am repeating the name of the case. The name of the case is Sorab Sharma versus Principal Commissioner of Income Tax, and this case has been reported in 110 ITR Tribunal at page number 677. The date of the judgment is 22nd November 2023. Thank you, friends.